Thank you to all of you for joining us for our annual contract law update. For those of you who have joined us previously, welcome back. For those of you who haven't attended before, my name is Rowan Turrall and I'm a partner and head of dispute resolution team at Boyes Turner. And I'm joined today again by Sophie McDonnell, who's an associate in the team. It seems like a year has absolutely flown by since our 2023 update, and as usual, we've been keeping our eye out for cases which we can use to provide some handy hints and tips for in-house teams in relation to contracts. We've got 6 cases to review today. Sophie is going to deal with the first 3, which are going to be looking at limitation and exclusion of liability clauses from different angles. I'm then going to consider a case in which the Court of Appeal considered the incorporation of online terms through a click wrap procedure. I'm then going to be looking at a notice of claim under a share purchase agreement, and then I'm going to finish off with a Supreme Court case which addressed force majeure clauses and reasonable endeavours. Previously in these sessions, we've looked at the learning points alongside each case, but today we're going to do things slightly differently, and I'm going to wrap up all those learning points at the end together and consider some of the themes that have come out of this year's court contract decisions. Please feel free to use the Q&A box if you've got any questions that you'd like to ask us. We won't deal with those live during the session today, but we will follow up on those with you direct after the session. So please make sure that they're not anonymous so that we can send those back to you. And please also feel free to email us afterwards if you've got any follow-up queries that you think of after the session. We will circulate a recording of today's session after the event if you want to watch again or share with colleagues. And if you'd like a copy of the slides, we're more than happy to share those with you. Just drop us a line and we'll forward those on to you. So, Sophie, it's over to you for our first case.
Thank you, Rowan. Some of you may recall the Topperson and Rolls-Royce case from our termination of contracts update earlier in the year. In that session, Rowan looked at what happened on termination, but for today's session, we're going to look at the Court of Appeal's recent decision in relation to the application of a cap on liability. The contract in question was for Topperson to design, build and implement digital visualization software for Rolls-Royce. The project had not gone to plan and Rolls-Royce eventually terminated. Topperson issued proceedings seeking to recover sums due to it and Rolls-Royce counterclaimed for damages. The judge found in favour of Rolls-Royce in relation to the termination and found the sum due by way of termination damages was just under €8 million. She reduced that amount by sums which were found to be due to Topperson, and at the time of the termination, this amounted to just under €800,000. She then applied the contractual cap of €5 million and awarded Rolls-Royce €5 million as damages. There were 2 grounds for appeal, and I'm going to look at the first of those, which was that the contractual cap should be applied where there was a set-off between monies owed between the parties. Topperson appealed on the basis that there was a set-off. The cap should be applied to each party's liability to the other. The 2 sums then should be set off against each other at that stage. The effect of this would be to reduce Topperson's €5 million liability by the €800,000 which was due to it. The Court of Appeal looked at a number of clauses to decide whether Topperson's approach was correct, and I've set out the slide, the wording of Clause 20, which the key provisions, it stated that, subject to Clause 20.1, the total liability of either party to the other under this agreement shall be limited to aggregate for all claims, no matter how arising, to the amount of €5 million. Topperson's main submission can be summarised as follows. Clause 20 referred to total liability of the parties to each other and not to net liability once claims and cross-claims have been considered. The interpretation of Topperson reflected commercial common sense. The judge's interpretation gave Rolls-Royce the opportunity to take advantage of its own wrong by withholding payments to Topperson and then on termination recovering the full €5 million cap without accounting for payments it should otherwise have made. In response, Rolls-Royce argued that total liability was the aggregate for all claims no matter how arising. Any rights of set-off were part and parcel of working out the total liability, and once that process was completed, the cap was to be applied. Rolls-Royce also relied on the recent case of Triple Point Technology and PTT in support of the proposition that in the absence of clear words, the court will assume the parties did not intend to give up their normal rights and obligations. The Court of Appeal found in favour of Topperson on this point and allowed the appeal. In his judgment, Lord Justice Coulson found there was nothing in Clause 20 which suggested that the cap was only to be applied once the net financial position between the parties had been calculated. The words total liability suggested totting up, not netting off. He also considered those words positively, indicating that the cap had to be applied to Topleson's liability to Rolls-Royce and Rolls-Royce liability to Toplesson. The words indicated that each party's liability to the other would be assessed, with each of those liabilities being subject to the cap. In this case, the application of the cap to Rolls-Royce's liability to Toplesson made no difference, as it was less than the 5 million figure, but it did reduce Topleson's liability to Rolls-Royce prior to the netting off exercise. Lord Justice also noted that this construction accorded with commercial common sense. Rolls-Royce's argument in respect of clear words being also failed to gain Lord Justice Coulson's support. He recognised that a contractual cap is at least potentially a denial of both parties' common law rights, but it is a commercial limit designed to promote certainty. It is a blunt instrument which may ride roughshod over what might otherwise have obvious rights and obligations. In summarising, he concluded that the judge was wrong in her construction of the cap. The liability of each party was to be separately assessed and subject to the cap being set off applied. This conclusion arose, he said, from the words actually used and from the commercial common sense. Therefore, the amount awarded to Rolls-Royce was reduced from 5 million to 4.2 million. The next case of Cost-Cutter Supermarkets Group Limited and Vaish was an appeal to the High Court in relation to the judge's interpretation at first instance of a limitation of liability clause. There was also a cross-appeal, which I'm not going to cover today. The background of the case was a relationship between Cost-Cutter and the defendants, pursuant to which Cost-Cutter sold goods to the defendants for onward sale in their convenience stores. Originally, Cost-Cutter sourced these goods through NISA, but then changed to acquire them from a company called P&H. The level of service dropped as a result of this change, and the defendants complained. They decided to leave Cost-Cutter and join the SPAR symbol group instead. Cost-Cutter issued proceedings to recover sums that they claimed were still due for goods which had been delivered but not paid for. The defendants counterclaimed for losses said to have been suffered as a result of the poor service. At first instance, the counterclaim was dismissed and that part of the judgment was not appealed. However, in relation to the claim for payment, the judge found that the effect of the limitation of liability clause in some of the agreements between the parties was to cap the defendant's liability under those agreements to zero, and therefore Cost-Cutter was unable to recover the sums claimed. Cost-Cutter appealed in respect of those parts of the decision. The clause in question was clause 19.2, which I've included on the slide. This clause stated that subject to clause 19.1 and 18.1, the total liability of either party shall, in respect of all acts, omissions, events, occurrences, whether arising out of any tortious act, breach of contract or statutory duty, or otherwise arising in any particular contract year, in no circumstances exceed in sum equal to 5 times the service charge paid by the retailer to the consultant in respect of the contract year immediately prior to the contract year in which such claim was made. It happened that the service charge for the relevant year was 0, which the judge found resulted in the cap being set at 0. The highlighting on the slide is mine and in the wording which the judge relied on to find that the cap applied to the claim for unpaid invoices. In his judgment, the judge disagreed with Cost-Cutter's submission that the clause could not limit the defendant's liability for the debt, and said, in my view, a debt constitutes an omission to pay the price due under a contract. It arises out of a breach of contract or otherwise. Accordingly, it seems to me the defendant's liability is limited to 5 times the service charge paid in the year preceding the claim by Cost-Cutter. It was this part of the judgment and the construction of clause 19.2 which was appealed. I can imagine at this point a number of you are shifting in your seats, nervously thinking about whether your standard terms might inadvertently limit your ability to recover unpaid invoices. Fear not, the appeal judge came to Cost-Cutter's rescue And before considering what he had to say, I thought it would be helpful to set out the summary from the judgment of the relevant approach to the construction of contracts, which is taken from the cases such as Arnold and Britton. The court otherwise construes the relevant words of a contract in their documentary, factual and commercial context. It considers 1, the natural and ordinary meaning of the provision construed, 2, any other relevant provisions of the contract, 3, the overall purpose of the provision and the contract, 4, the facts and circumstances known or assumed by the parties at the time of execution, 5, commercial common sense, and disregards subjective evidence of parties' intentions or fact not known or reasonably available to both parties at the time of the contract. The starting point is the language used, and where the parties have used unambiguous language, the court must apply it. That is the case even if the outcome is improbable or extremely commercially disadvantageous to one party. The court's function is not to relieve a party from a bad bargain when interpreting an agreement. Where language is unclear, the court can depart from natural meaning where an alternative meaning more accurately reflects what a reasonable person with the party's actual and presumed knowledge would conclude the parties had meant. If there are 2 possible constructions, the court will favour the one consistent with business common sense. Those are principles apply to general contractual interpretation, but the judge also reminded himself of the specific authorities in relation to limitation of liability clauses. He referred to the judgment of Lord Leggett's in the recent Triple Point Technology case, in which he said, the court in construing the contract starts with the assumption that in the absence of clear words, the parties did not intend the contract to derogate from the normal rights and obligations. Looking at the case in question, the judge noted that the obligation to pay is a primary obligation and liability to pay damages is a secondary obligation. An action for the price of goods arises on non-payment and is unrelated to the separate cause of action, which arises out of the fact that the omission to pay was a breach of contract. In failing to recognise this distinction, the appeal judge found that the judge at first instance had fallen into error. In his view, the words in clause 19.2 were not directed at removing the primary obligation on the defendants to comply with their obligations to pay for goods. The claim to enforce that primary obligation is not a claim for breach of contract, even though that claim would sit alongside. The words or otherwise were not sufficiently clear to have the effect of excluding any claim relating to enforcement of primary obligations. The judge also said that even if his analysis was not correct, a construction which effectively led to the defendants avoiding the primary obligation to pay and have no liability for damages was so extreme that the clearest of wording was required to achieve such an improbable outcome. The appeal was therefore allowed. The next case of Innovate and the University of Portsmouth is relatively long and relates to the publication of a research paper which contained a number of errors. The key point that I want to extract from it relates to the interpretation of a limitation of liability clause. The full background isn't necessary to understand the key issues, but to give some context, I can summarise as follows. Innovate holds the patent for formulation of liquid aspirin, which it was hoped could be developed to be used as a treatment for certain types of brain tumour. It entered into research agreement with the defendant to undertake a research programme in relation to the drug. As part of its work under the research agreement, an academic research paper by the defendant's team was published in a cancer publication, which set out the results of testing of the drug. The paper was said to be littered with errors and was subsequently retracted by the publication. Innovate issued proceedings against the university seeking damages arising from the publication, including the costs of repeating the research previously undertaken and for reduction in value of the patent. Innovate was argued that the errors in the journal were at least careless, but were also said to be the product of dishonesty. This was of relevance in relation to the application of the limitation of liability clause. The clause stated as follows: except as provided in clause 11.5, the university is not liable to the funders because of any representation unless fraudulent, or any warranty, express or implied, condition or other term or any duty at common law, non-observance or non-performance of this agreement for any loss of profits, business contracts, opportunity, goodwill, revenues, anticipated savings, expenses, costs, or other similar loss. 11.5, the liability of a party to another householder arising, including negligence in respect of or attributable to any breach, non-observance or non-performance of this agreement or any error or omission, except in the case of death or personal injury or fraudulent misrepresentation, shall be limited to 1 million. The university accepted that a party cannot contract out of its own fraud in inducing the making of a contract. However, it submitted the same could not be said with regards to the performance of a contract. The judge had to consider whether the limitation clause would apply in the event it was found that the publication of the paper was dishonest. The judge was keen to take through various authorities and set out another helpful summary of the key principles in relation to exclusion clauses. Exclusion clauses mean that what they say. It is a matter of construction rather than law as to whether liability for deliberate acts will be excluded. Limitation clauses are not regarded by the courts with the same hostility as exclusion and indemnity clauses. A contracting party cannot exclude liability for its own fraud in inducing a contract. As to whether a clause excludes liability for fraud in performance of a valid contract is a matter of construction of the commercial provisions and risk allocation. An exclusion or limitation clause is more likely to be construed as effective if it is excluding the liability for fraud of an agent or employee rather than the fraud of the contracting party itself. The words howsoever arising are capable of affecting the exclusion of liability for willful default. Innovate's position was that neither clause 11.4 or 11.5 operated to exclude or limit liability where the relevant breach of contract was committed fraudulently. The university's position was that the clause only applied to a fraudulent misrepresentation, which was not a case being run by Innovate. Even if the court found that the breach of contract by the university was dishonest, the university contended it was still able to rely on clause 11.4 and 11.5. The judge agreed that the clause only applied to fraudulent misrepresentation and not to a breach of contract committed fraudulently. Innovate also sought to argue that the clauses should not be given effect by reason of the Unfair Contract Terms Act. The judge summarised Innovate's position as being that because the two clauses limit recovery for breach of contract committed dishonestly, the two clauses were both unreasonable. The judge noted that UCTA does not allow the court to strike down a clause for some purpose but not others. A clause is either effective or ineffective in respect of the breach of all breaches of contract. The judge found that both clauses were reasonable. If Innovate's allegations of fraud were well-founded, they were highly unusual and highly unlikely to be in the contemplation of the parties when they entered the contract. The judge said he would slow to strike down the clauses because the matter's outside the contemplation. In the end, the judge found that the university was in breach of contract but did not uphold the allegations of dishonesty. The claim for damages was said to be in the excess of 100 million. The application of the cap meant that Innovate's damages were awarded was limited to 1 million. I will now pass you back to Rowan, who is going to firstly talk about the case of Parker, Grennan and Camelot UK Lotteries.
Thank you, Sophie. So my first case concerns a question which may trouble a number of you who contract online with consumers. And in the case, the Court of Appeal described the dilemma for online traders as follows. How do they bring their standard terms and conditions of trading sufficiently to the attention of prospective customers to incorporate them in the contract of sale or contract for services without testing their patience so much that they decide to take their custom elsewhere and without impeding the rapid turnover which may be the key to the profitability of their trade? Is it ever going to be possible to overcome the fact of life that most people, dare I say it, even lawyers, will not bother to read the small print before clicking on the box or button which states, I have read and accept the terms and conditions? Lady Justice Andrews said that as far as the court was aware, this was the first time that the issue of incorporation of terms into a contract made online had been before the Court of Appeal. And although encouraged to do so by the appellant's counsel, she declined the opportunity to use this case as an opportunity to lay down principles of general application or to give guidance about what will and will not suffice to bring standard terms to the attention of a consumer. Even so, I think there's some useful comments which can be taken on board for those of you who share this concern, although obviously each case is going to depend on its own facts and the wording of the contract in question, bearing in mind the lack of general principles that the court would not give. So in starting her judgment, the judge referred to an extract from Chitty, which had also been set out in the first instance judgment, and which summarises the leading authorities regarding incorporation of standard terms. I find that these summaries are often useful to set the rest of the judgment into context. So what she said here was it's not necessary that the conditions should have been read by the person receiving them or that they are made subjectively aware of their effect. If they knew the person receiving the document, so if the person receiving the document did not know there was writing on it, they are not bound. If they knew the writing contained or referred to conditions, then they are bound. If the party tendering the document did what was reasonably sufficient to give notice of the conditions and the other knew there was writing but didn't know it contained conditions, the conditions will become terms of the contract. She also recognised there had been subsequent case law and statute which had developed to protect the weaker party, most recently the Consumer Rights Act. So, by way of background to the case, it was concerned with a National Lottery online game called the £20 million Cash Spectacular. The appellant had registered for a National Lottery account which allowed her to play the game online. The prizes for this particular competition ranged from £5 to £1 million, and the outcome of each game was predetermined by Camelot's computer system at the point of play. A random number generator would select a number which corresponded with the prize. A player could choose if they wanted to play without any animations on the screen, in which case they just simply received a message saying whether they'd won or not, and if so, how much. When they were playing with the animations, the upper section of the screen showed a box labelled winning numbers, and the lower section had a box labelled your numbers. To win, a player had to click various bits and pieces on the screen and to match any of the winning numbers with any of their numbers. If there was a match, then the two matching numbers would turn white and flash. The appellant played this game on her laptop, and when she pressed play, the random number generator selected a number which meant her ticket had won £10. After the final number was clicked, the screen displayed a message saying, "Congratulations, you've won £10." However, she noticed that there were two other numbers that matched in the upper and lower sections of the screen. They weren't flashing, but it was the matching prize figure for £1 million. So she took a screenshot and rang Camelot, but didn't click the finish button. She was told that the game wasn't over until she clicked that finish button, and when she did, her prize was £10, and that was the amount credited to her account. Now, the reason that she had been shown these two numbers was a coding issue in the script for the animations, which only appeared in certain instances and for a fairly short period of time. But the effect of the issue was that numbers corresponding to the £1 million, although they didn't flash, did still appear on her screen when they shouldn't have done so. The appellant issued proceedings against Camelot, alleging she should have won £1 million and applied for summary judgment. In brief, her case was that the game screen stated she had to match any of the winning numbers to any of her numbers to win the prize. She had done that, and if there was a software error that showed something different, then that was Camelot's problem and not hers. At first instance, the judge found in favour of Camelot. The appellant appealed on three broad issues, but I'm only going to look at the question of whether Camelot's terms were incorporated into the contract. There were three relevant sets of terms and conditions, and in order to open her National Lottery account in the first place, the appellant had to perform a click-wrap procedure, which confirmed that she had read and agreed to be bound by all the terms, which were accessible via a series of hyperlinks or drop-down menus. When updates to those terms took place, there would be a notification page stating there had been updates with a hyperlink to the amendments. If there were significant changes, then those had to be accepted again by clicking the Accept button. The account terms contained a provision which said that the various rules could be viewed on the website, but they could also be obtained by writing to or phoning the customer care team to request copies. One of the submissions made on behalf of the appellant was that Camelot had not done enough to draw the terms to her attention because there was nothing on the website to force an account holder to look at the terms before accepting them. The online equivalent of signing a physical set of terms and conditions was submitted to be a link to the terms with the accept button at the bottom. So at the very least, the consumer had to scroll down through them before engaging in the click wrap exercise. Lady Justice Andrews did not accept that forcing a consumer to go through that exercise would make it any more likely that they would read the terms and conditions. Forcing them to read through pages of small print was more likely to cause them to become fed up and quit the website. She said that one cannot force someone to read the terms and conditions if they cannot be troubled to do so. The trader only needs to bring the terms and conditions to their attention, which in my judgment necessarily involves giving them a sufficient opportunity to read them. Depending on the facts and the circumstances of the particular case, a sufficient opportunity may be afforded by providing a hyperlink to the terms or a drop-down menu which the consumer can click or not as they choose. She did, however, go on to say that following a click wrap procedure does not mean that all terms and conditions will be incorporated into every case of an online contract for goods or services. There might be situations, for example, where the transaction is time limited so that the consumer does not have time to read the terms and conditions if they wish to do so, or in which there are so many links that the relevant terms cannot truly be said to be easily accessible. In this particular case, though, enough was done to incorporate the terms into the contract, and by adopting the click wrap procedure, the appellant was bound by those terms. Interestingly, Lady Justice Andrews concluded her decision by flagging that the issues in this case highlighted the complexity of balancing the needs of online traders to publicise their terms with the needs of consumers to access and understand them. She considered the time might be right for the Law Commission to review this area again, given that a decade has passed since it last did so. So my next case is the case of Drax Smart Generation Holdco and Scottish Power Retail Holdings Limited. And it's a bit of a cautionary tale in relation to the giving of a notice of claim under a share purchase agreement. As is often the case, the agreement in question required the buyer to notify the seller within a specified deadline if a claim had arisen, failing which the seller wouldn't be liable. The dispute in question related to an agreement under which Scottish Power sold shares in a company to Drax for £702 million. One of the assets of the company was a site in Kent, which was a potential site for a new gas power station. However, if it was to be built, it required a connection to the national grid, for which there would need to be an agreement to lay cables over an adjoining parcel of land. An option agreement was in place, giving the right to obtain an easement for those cables to be laid, but for various reasons, when the company gave notice to exercise that option a few months after the SPA had been signed, it transpired the option was of no effect and it had fallen away. The SPA had included terms by which Scottish Power had warranted that the benefit of the option agreement would be assigned to the company prior to completion. The notice provision in the SPA, which is common to many provisions that we see, required the buyer to state in reasonable detail the nature of the claim and the amount claimed, detailing the buyer's calculation of the loss thereby alleged to have been suffered. A notice was given, which was over 9 pages long and gave details about the claim. However, the seller argued it did not satisfy the contractual requirement and was therefore invalid. Drax had previously given a notice of a matter which gave rise to a claim and summarised the events which had led to the option falling away, and there had been further correspondence between the parties, including an agreement to extend the time limit under the SPA for bringing certain claims. But when they served the actual notice of claim under the agreement, it was given on the last possible day for giving notice. It set out various respects in which it was said that the claim had arisen, and under the heading of loss, it stated that the loss suffered was yet to crystallise. However, the notice estimated the loss based on 2 different calculations. The first was by reference to the estimated cost of acquiring an easement from the landowner, and the second was an estimate of the cost that would be incurred if there was a potential compulsory acquisition. Scottish Power didn't accept liability, and so Drax issued proceedings. In its initial particulars of claim, it made clear that the alleged losses would be incurred in obtaining the easement, and those were losses which would be suffered by the company rather than by Drax itself. It subsequently sought permission to amend to delete the reference to losses suffered by the company and instead to advance the case that the loss suffered by Drax was the difference between the warranted value of the company at the completion date and its true value. At first instance, the judge found that the reasonable recipient of the notice would have understood it as claiming a loss suffered by the company for which Drax was liable, and did not reflect the claim that Drax was now seeking to pursue in the amended draft particulars. If Drax's claim was one for diminution in value of the shares, the judge said that that's what should have been set out in the notice of claim. Drax therefore appealed. In the Court of Appeal, Lord Justice Mayall set out the test that should apply. I've included it on the slide, but it's quite long, so I'm not going to read it all out. But the key point is that whether a notice in this instance is sufficient to satisfy the clause under which it will given will depend on the language of the clause itself. He was keen to emphasise that notice of claim clauses should not become technical minefields. When reviewing the clause in question, Lord Justice Mayall could see nothing in the language of the clause or its commercial purpose which required Drax to spell out that its claim would be based on the difference in the value of the shares, which is what it was ultimately seeking to claim. Imposing such a requirement served no particular commercial purpose and introduced a trap to defeat what might otherwise be a valid claim. There was no challenge to Drax's good faith in formulating the notice of claim, and so what it put forward when it gave that notice of claim was, at the time, its calculation of the loss it alleged it had suffered. Lord Justice Mayall said there was nothing in that clause which set the initial calculation in stone. If further reflection meant the calculation was legally unsound or capable of improvement, there was no good reason to hold the buyer to its calculation that it had set out in its notice of claim. The notice was therefore found by the Court of Appeal to satisfy the requirements of the notice of claim clause, and the appeal was allowed. There's a fairly substantial amount of money in dispute here, and the claim would have fallen at the first hurdle if the claim was not correctly notified. So I suspect that was a massive relief to all involved on the buyer's side. So for my final case this morning, I'm going to look at a Supreme Court case from earlier this year in which the court looked at force majeure clauses. For a long time, these cases only seem to pop up from time to time, but in recent years, it seems that these sorts of clauses are more and more under the spotlight due to global events such as COVID, various sanctions and conflict. This particular case arose out of sanctions imposed by the US authorities on RTI's parent company, which had the effect that it was subject to the same restrictions as its parent. The contract was a charter party, which required payments to be made in US dollars. MUR sent a force majeure notice indicating that it was prevented from accepting payment in US dollars because of the US sanctions. RTI rejected the notice and offered to pay in euros instead and to bear additional costs or exchange rate losses as a result of any currency conversion. The force majeure clause defined what a force majeure event is, and that included various different events. But it also stated that it had to meet the criteria that it could not be overcome by reasonable endeavours from the party affected. MUR's position was that a reasonable endeavours proviso such as this was directed to a situation in which the impediment could be surmounted so the contract could be performed in accordance with its terms. It said it did not extend to varying the contract and/or the performance, and the judge at first instance agreed. The contractual rights to payment in dollars formed part of the parties' bargains in this particular contract. The exercise of reasonable endeavours required endeavours towards the performance of that bargain. However, the Court of Appeal took a different approach. Lord Justice Mayall considered the appeal was related to the specific terms of the clause and what was meant by it. The real question, he thought, was not what reasonable endeavours required, but whether payment in euros would overcome the state of affairs caused by the sanctions. In interpreting the clause, he said that state of affairs and overcome were non-technical terms and that the clause should be applied in a common sense way. Lord Justice Newey agreed that this was an issue specific to the wording of this clause and was not about general principles. In his view, it was sufficient if the force majeure clause could be overcome in a practical sense, such that all its adverse consequences would be avoided. It was not a clean sweep, though, in the Court of Appeal. The final judge, Lord Justice Arnold, giving a dissenting judgment, said that an event or state of affairs was not overcome by an offer of non-contractual performance. The party invoking the clause was entitled to insist on contractual performance. If the clause is intended to extend to non-contractual performance, then clear express words were required. So we carry on up the chain, and it went before the Supreme Court earlier this year. Before the Supreme Court, MUR argued that in the interest of certainty, reasonable endeavours provisos in force majeure clauses should not be extended to offers of non-contractual performance unless the parties expressly agree. On the contrary, RTI argued that a reasonable endeavours proviso requires the party invoking the clause to accept an offer of non-contractual performance if it involves no detriment or prejudice to the other party and it achieves the same result as contractual performance. In accepting MUR's case, all 5 judges of the Supreme Court accepted MUR's case and considered a number of principles. Firstly is the question of causation. To be able to rely on the clause subject to wording to the contrary, the affected party must show that the event caused their failure to perform, establishing that the failure to perform couldn't be avoided by exercising reasonable endeavours. And in this context, performance means contractual performance. The object of the reasonable endeavours proviso is to maintain contractual performance and not to substitute a different performance. Second, the court considered the principle of freedom of contract. That includes the freedom not to contract, which in turn includes freedom not to accept the offer of a non-contractual performance of the contract. Thirdly, and as we'll see elsewhere in these cases that we've discussed today, clear words are needed to give up valuable contractual rights. MUR had a right to insist on payment in American dollars because that was the contractual bargain that had been agreed between the parties in their agreement. Lastly, the court considered the importance of certainty in commercial contracts. There was concern that if reasonable endeavours needed to be considered in relation to non-contractual performance, then that would introduce uncertainty. In the judgment, it said it's not in dispute that reasonable efforts import some degree of uncertainty. But for that concept to be allowed to ride roughshod over the required contractual performance would be to introduce unwarranted uncertainty and would thereby, it might be said, undermine the expectations of reasonable business people. It is not unmeritorious or unjust to insist on contractual performance, all the more so if being precluded from doing so would introduce uncertainty contrary to the expectations of reasonable business people. So I've added in a quick visual of the way in which the court decisions went at each level. And if you tie that back into the Topperson case, you can see that we have difference of opinions at different levels of the court. In the Topperson case, for example, you might have read the first instance judgment and thought, yes, that's what the clause says, and then read the Court of Appeals decision and thought, hang on a minute, maybe it doesn't. It just serves to show the difference that a few words can make in a clause and why, when you ask a litigator whether you're going to win a case, they're unlikely to answer with a definite yes. So I'm going to finish up by just wrapping together a few of the threads from those cases that we have looked at this morning. Looking first at the court's approach to interpretation of contracts over the last year, we've seen a continued application of principles from recent cases like Arnold and Britton and Triple Point. There's been a focus from the court applying an interpretation which aligns with commercial common sense and being slow to remove parties' rights and obligations unless clear words are used. However, a big word of caution. It's really important to recognise that the court will only consider commercial common sense if the clause in question is ambiguous. If the wording of a clause is clear, the court will apply it, even if the result is commercially disastrous for one of the parties. The court will not rescue you from a bad bargain. When I was training, my supervising partner used to use the expression, say what you mean and mean what you say. And I've also found a Dr. Seuss quote, which is, I meant what I said and I said what I meant. And although I don't think Dr. Seuss had principles of contractual interpretation in mind when he wrote those words, I think they are useful phrases to have in mind when you're reviewing a clause that you've either drafted or you're amending. Do those words that you've used properly reflect what you intend the clause to mean? Or could it be subject to a different interpretation? I recognise that litigators like myself and Sophie have the annoying habit of criticising drafting with the benefit of hindsight. But I think when you're reviewing limitation and exclusion clauses in particular, it can be useful to think through the clause from the perspective of what happens if this all goes wrong. Whether it's a contract for the sale of goods or services or whatever it might be, what are the most likely things that might go wrong which could impact on your business? Would those clauses impact your ability, for example, to make a full recovery if you're the one that's going to be seeking payment? Or are they going to protect you from being fully liable to your counterparty in the event that you're the one that's delivering the goods or services or equivalent? Is there anything you can think of which is quite likely to happen in the worst case scenario, which might squeeze through a gap in those clauses or unexpectedly be caught? When you're looking at caps on liability, consider carefully where you've used words like total or aggregate or claims, and whether they're sufficient for your purposes or might have unintended consequences. If there are particular things that should fall outside of a cap on liability, then you should probably say so. Words like howsoever arising and or otherwise are often put into clauses as a catch-all for anything that you might have missed. And whilst often they can be very useful, in the cost cutter case, the words or otherwise weren't seen as wide enough to exclude a claim in relation to enforcement of a primary obligation. But in the University of Portsmouth's case, the words howsoever arising were capable of affecting an exclusion of liability for willful default. It's important to note that in both cases, those words are construed in the context of the wider clauses in which they appeared, but just flagging to give you a bit of pause for thought if you come across those words in a clause, to think through whether they are actually going to capture everything you want, or whether you're going to need to put some express words in to capture something particular. Thinking next about the incorporation of terms in online contracts. As I said, the court refused to provide general principles, but I think there are some actions which were taken by Camelot which can be said appeared to find favour when the court was considering incorporation. Those included updates to the terms being clearly flagged when somebody was having an online account that they kept going back into, and substantial amendments to the terms needed to be reaccepted. Also, terms and conditions being available by post. My reading of the case is that although the court accepted you can't make a consumer read terms that they don't want to, you still have to present your terms in a way where they can be easily accessed and read by those who want to go through them and given time to do that. So if you've got a website that limits the time that a consumer has to conclude their purchase, it seems likely that it's going to require a higher threshold for incorporation, and you're going to have to be even more careful to ensure that the user of the website has time to click through different links, to review different sets of terms and conditions if necessary, and that those are easily accessible. If it's going to take them a lot of time to click through everything and a long time to find what they need, that may be problematic for you. Looking next at notice of claims under SPAs, the main point from the case is that the court is not going to be keen to hear technical arguments about compliance with notice clauses and whether a notice satisfies the requirements of that clause. But having said that, it's really important to ensure that the wording of such clauses is clear in relation to what is required to be notified and when. If you're serving a notice, then you need to ensure that information is included, that it's served in time at the right place and the right method. In this particular case, it all worked out okay for the party seeking to rely on the notice, but it could have gone the other way. The judge also noted in that particular case that the notice was served on the last day it could have been served. And whilst that had no impact in the particular case, do try to avoid that if possible. Sometimes easier said than done, but it helps everybody's blood pressure stay a little bit lower. And lastly, on force majeure clauses, again a reminder that if you want one party to give up valuable contractual rights, you're going to have to spell it out in your clauses. There may be reasons why you would want to include a provision that reasonable endeavours should include non-contractual performance. If so, you're going to have to specifically set that out, but do be wary of creating a clause which is full of uncertainty. So that concludes our session for today. Thank you again very much for joining us, and we hope that you found it useful. Please do get in touch with us if you've got any follow-up questions or you've got any issues that we can assist you with. Our contact details are on the bottom of that slide, which I've just popped up on the screen. Please also keep your eye out for the other events that we run for in-house lawyers. We've got another series of events which we'll be running next year, and we'll hope you'll be able to join us for some of those. We also provide updates on LinkedIn as well, so please do feel free to connect with us to find out more about what's going on. Thank you again for joining us, and goodbye.